Welcome to Criminal Procedure 201A. First, let's start with an introduction. My name is Faith Welch. I attended Union Commonwealth University when it was still Union College, where I majored in history. I then attended the University of Dayton School of Law, where I was the managing editor of Law Review and a teaching assistant for legal writing. After graduating law school, I moved to Fort Wayne, Indiana, where I started my career with the Allen County Prosecuting Attorney's Office. While there, I worked in the Drugs, Guns, and Gangs Division, where I prosecuted felony offenses. After I left the prosecutor's office, I joined my current firm, Haller Colvin, where I currently practice bankruptcy law, criminal defense, and civil commercial litigation. I have had the opportunity to defend clients charged with murder, possession, and sexual assault cases, and frequently find myself in federal court. Our goals throughout this course will be to learn the difference between criminal law and criminal procedure, learn the challenge of balancing security interests and privacy rights, learning the overall objectives of criminal procedure, to learn the stages of the criminal justice process, the sources of criminal procedure, the structure of the federal and state court systems, the role of precedent and decision making, and the role of judicial philosophy. While the list may sound long, many of these topics are implicit in the study of criminal procedure, and you will pick up on them swiftly as we move through the course. The court opinions that are contained in your textbook are not an accurate reflection of how the original case was published. In Chapter 2, you will review the case of Rochin v. California, 342 U.S. 165, 1952. The format in your textbook is not the format of the actual court opinion, but serves to break down the complex nature of cases to be easily understood in a 200-level course. Your textbook has broken down the cases we will review into separate subsections: the facts, the reasoning, the holding, and concurrences and dissents. As the semester continues, we will review some cases from outside of your textbook. At that time, we will discuss how to review those cases in a thorough and understandable fashion. Why study criminal procedure? You may be taking this class to fill an elective, meet a core requirement, or because you thought the course sounded interesting. However, studying criminal procedure has multiple uses. First, the study of criminal procedure is practical. If you are ever pulled over on the side of the road, it is important to know your rights. You should not rely on the law enforcement officer pulling you over to explain your rights to you. Second, if you are looking to have a career in criminal justice, whether that be as a member of law enforcement, as an attorney, as a judge, or a legislator, understanding criminal procedure is essential to a well-rounded professional background. Third, it is far too often that people do not know their constitutional rights. While the United States Constitution is a pretty cool piece of paper, the principles found within it are the foundation upon which our country was built and upon which your rights rely. Fourth, judicial insight. In this day and age, with the growing reach of social media, it is important to be able to understand why courts are making the decisions they are. I can't tell you how often I go to family functions to hear family members discussing the latest court case, with no understanding of the meaning behind it. Understanding how judges decide cases can give you the knowledge to see the true process behind landmark rulings. Finally, public policy. Public policy is constantly changing and evolving. For example, marijuana used to be considered a criminal offense in every state and at the federal level. However, as public policy has evolved, nearly half of the United States, including DC, have legalized recreational marijuana use. This was, in part, due to the public policy surrounding criminal procedure, as we will discuss later in this course. What is the difference between criminal law and criminal procedure? Well, criminal law defines the offenses necessary to commit a crime, which requires not only those affirmative acts, but also intent, the act itself, and a resultant harm. Criminal procedure, on the other hand, is the procedure for the investigation, arrest, and prosecution of violations of criminal law. Criminal procedure helps regulate law enforcement authority. The American system of criminal procedure holds tight to the belief that fair procedure will produce accurate results. Unfortunately, this is not always the case. Often, people feel the system is broken when individuals who appear guilty rely on legal technicalities to gain their freedom. However, it is far more often the case that criminal defendants are taken advantage of due to loopholes frequently exploited in the criminal procedure mechanism. However, criminal procedure is meant to protect individual freedoms and privacy interests. Your interest in your home, personal property, and your person are all freedoms and privacy interests criminal procedure is designed to protect. The more legal barriers there are, the more difficult it is to bring criminals to justice. However, too few legal barriers result in coerced convictions, unlawful searches, and false convictions. Further, the state of the nation has also shifted the scale of balance in weighing criminal procedure rights. In times of war or other national security threats, the overall safety of society at large has been far more important than the privacy rights of the citizenry. The objectives of criminal procedure are numerous. First, the system should be accurate, convicting the guilty and protecting the innocent. Second, the system should be efficient, so that cases do not linger for extended periods of time. Third, the system should be founded on respect, both for the criminal defendant and the victim. Fourth, the system should be fair, and the public at large should also believe that the system is fair. Fifth, the system should treat all subjects to it equally, regardless of one's socioeconomic status, race, ethnicity, sex, sexual orientation, or age. Each person should receive equal treatment under the law. Sixth, the system is inherently adversarial, and the defendant should have the right to be represented by trained lawyers and advocates at crucial points in the criminal justice process. Seventh, the system should encourage active participation, not just among the parties, but the public at large, through service on juries. Eighth, the system should entertain the right to appeal. Juries, judges, and lawyers sometimes get it wrong, and an individual's freedom should not be dependent on the opinion of a single judge or jury. Appeals provide a mechanism to ensure the defendant was treated in a manner that doesn't offend the notion of freedom. Finally, the ultimate goal of the criminal justice system is that the implementation of the rules of criminal procedure should result in a just outcome, not only for the victim and society, but also for the defendant. I have included attached to this slide the same image from your textbook, Figure 1.1. Figure 1.1, in extensive detail, walks through the criminal justice system, from the commission of the crime to a criminal defendant's eventual ouster from the system. This guide, while comprehensive, is not the most clear and easy to follow. A more simplified version of Figure 1.1 is seen here in this chart. Assuming a criminal defendant is guilty of the crime, the process is as follows. First, the commission of the crime. We, of course, cannot begin an investigation without the minimum suspicion that a crime has been committed. Second, the investigation. An investigation can be as simple or as complicated as it needs to be. For example, a simple investigation would be a person pulled over on the suspicion of drunk driving. They were being investigated when the officer first observed their driving behavior. The subsequent portable breath test and sobriety test are just in furtherance of the investigation. This investigation may only take a few hours. However, take a drug dealer. A drug dealer is likely suspected after law enforcement receives some sort of tip. The officers then begin investigating via stakeouts, general observations, and investigation into the suspect's criminal history. Officers may continue their investigation through the use of confidential informants, who are used to conduct controlled buys or otherwise observe the action of the drug dealer firsthand. Then, officers may apply for a search warrant to search the drug dealer's home or place of business. An investigation like this may take months or even years. These are all examples of the investigation process. Third, the arrest. This can occur either with or without a warrant. However, be aware that an arrest is not the only way an officer can stop an accused individual. An individual may be detained without being formally arrested. Fourth, the charging decision. This portion of the process is a collaboration between the prosecution and law enforcement. After reviewing the facts and evidence obtained, law enforcement will typically recommend certain charges to the prosecutor. The prosecutor then has the responsibility of reviewing the facts and evidence and making a final determination about whether the crime fits the facts, if another crime fits the facts, if there's not enough evidence to support a crime, or if a suspect's due process rights were violated such that the evidence procured cannot be used. Fifth, the pretrial process. After filing formal charges, a criminal defendant then proceeds through the pretrial process. This includes an initial hearing, preliminary hearings, bail or detention hearings, discovery, hearings on motions to suppress, dismiss, or otherwise. The pretrial process may also consist of the presentation and acceptance of a plea agreement. While some practitioners consider a plea agreement part of the trial process, I don't agree. If a plea agreement isn't accepted, or if there's not a substantial basis or factual basis to support it, there's still the potential to move forward towards trial. So I believe it is more accurately reflected in the pretrial section rather than in the trial section. Sixth, the trial. A criminal trial is a large culmination of the evidence presented and a lawyer's expertise in arguing to a jury or the judge. The prosecution must always go first in presenting their case, as they have the burden of proof. The defendant may then choose to present a defense or to rely on the prosecution's case falling short. Seventh, the sentencing. If a criminal defendant is found guilty, then they proceed to sentencing. Sentencing in federal court varies greatly from sentencings in most state courts. The federal criminal system abides by certain mandatory sentencing guidelines, including mandatory minimums and enhancements. Some state courts follow this system, but give far more deference to the judge in determining the appropriate range of punishment. 8. The appeal. If a criminal defendant feels as though the judge, jury, prosecutor, or even their defense counsel got it wrong, they have the right to appeal. However, they can waive this right if they accepted a plea agreement. The sources of law for criminal procedure are primarily the United States Constitution, judicial decision, court rules, and state constitutions. Common law is judge-made law brought over from England to the United States. Common law is less often used as a primary source for criminal procedure, but more as a method of determining the meaning of our primary sources. The federal rules of criminal procedure are detailed rules drafted by federal judges and approved by Congress. These rules are essential to the proper defense of criminal defendants. Law enforcement agencies also have their own internal rules and regulations. For example, most police officers have a tow policy for vehicles that cannot be driven away from the scene. These tow policies likely have a rule regarding inventorying the vehicle. If an illegal substance or evidence is found during the inventory, and the police force can justify its policy, it may not be considered a violation of the defendant's rights to have searched the vehicle. While model codes are available, it is seldom that they are utilized by law enforcement, attorneys, or criminal defendants in the normal course. The federal court system is established by Article 3, Section 1 of the United States Constitution. As a reminder, Article 1 of the United States Constitution established the legislative branch, and Article 2 of the United States Constitution established the executive branch. Article 3, Section 1 reads, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." The federal court system is extensive. At the lowest level are the district courts. At the intermediate or medium level are the courts of appeal. And finally, at the highest level is the Supreme Court of the United States. Throughout this course, I will regularly refer to the Supreme Court as SCOTUS. As previously noted, district courts are the lowest level of the federal judicial system. There are 94 total judicial districts in the 50 states and territories. Although the district courts do not have appellate jurisdiction, they do have original jurisdiction over most cases. Courts of appeal are the intermediate or middle level of the federal system. The Court of Appeals has no original jurisdiction and can only hear matters that have come from the district court below it. There are 12 circuit courts, including D.C. Courts of appeal sit in 3-judge panels, or en banc, for important cases. En banc simply means that all of the judges in the circuit will sit to hear the case and not just the panel. Decisions in a circuit court are binding upon all district courts within the circuit. The number of judges in a circuit varies widely across the United States. As you can see here, the Ninth Circuit has 28 judges, while the First Circuit only has 6. See the attached map here, which is figure 1.3 in your textbook. This map outlines the various districts and circuits in the United States federal court system. Be advised that throughout this course, I'm going to make references to both Indiana and Kentucky, focusing on the districts and circuits in which Barberville, Kentucky, and Fort Wayne, Indiana are located. For example, Fort Wayne, Indiana is located in the Northern District of Indiana District Court and the 7th Circuit for purposes of appeal. Barberville, Kentucky is in the Eastern District of Kentucky District Court and the 6th Circuit for purposes of appeal. Knowing the district and circuit in which you are located is key to practicing law and reviewing precedent. For example, if I am in the Northern District of Indiana District Court arguing a motion to suppress, any 7th Circuit Court of Appeals case will be considered binding precedent that both I and the judge must follow. However, if I found a case to use from the Eastern District of Kentucky, that case would not serve as binding precedent. While I can still use it to show the court the route other courts are taking in similar circumstances, that authority is persuasive at best. It is essential to know the judge in front of whom you are practicing. Some judges will only recognize their own precedent or that within their district in reviewing briefings. Others are more open to reviewing the positions of other courts in different districts. SCOTUS is the highest court in the land. It is often referred to as the court of last resort. This is because if your appeal fails here, it is over, done, and decided. There is no further right to argue the merits of your case. SCOTUS's decisions are binding on every federal and state court in the United States. There are 9 Supreme Court justices with 1 Chief Justice and 8 Associate Justices. These justices currently include Justice Sonia Sotomayor, Justice Clarence Thomas, Chief Justice Roberts, Justice Samuel Alito, Justice Elena Kagan, Justice Amy Coney Barrett, Justice Neil Gorsuch, Justice Brett Kavanaugh, and Justice Ketanji Brown Jackson. SCOTUS is primarily an appellate court. In order to appeal to the Supreme Court, you must do so through a writ of certiorari. Despite its pronunciation, or likely because of it, many practitioners just refer to it as a writ of cert. Pursuant to the Rule of 4, 4 judges must vote to grant cert in order for the case to be heard by the court. Instances where SCOTUS has original jurisdiction include in matters where the case is between 2 states or where the case involves ambassadors. On one occasion, in United States v. Shipp, 1906, a criminal contempt complaint was filed directly to the Supreme Court, following the lynching of a defendant whose appeals to the court had been granted. The case brought against those responsible for the lynching gave the court original jurisdiction over a criminal case for the first, and thus far only time in its history. Just so you know, Shipp, the sheriff who failed to protect the defendant from the angry mob who lynched him, was found guilty of contempt of court. However, the maximum sentence for contempt at that time was 180 days. Shipp was only sentenced to 90. A collateral attack is a constitutional challenge by individuals who have been convicted and incarcerated and have exhausted their state appeals. The inmate bringing the case is known as the petitioner, as they have petitioned the court to review their case. The respondent is the prison warden or official responsible for holding the inmate. They are the party responding to the petition. These cases typically begin in the district court and work their way up to the Supreme Court. Habeas corpus is Latin for "you have the body." A writ of habeas corpus is an order issued by a judge to a government official, usually the warden of a correctional institution, to bring an imprisoned individual to court and explain why the individual is in detention. This is a guaranteed right under Article 1, Section 9, Clause 2 of the United States Constitution. Quote, "The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it." End quote. SCOTUS issues multiple types of opinions. The first is a majority opinion, which is when 5 or more justices agree. This results in a legal binding precedent. A justice may agree but want to write a concurring opinion with variances in their reasoning. A plurality opinion occurs when four justices agree, and other concurring opinions from justices comprise a majority decision. However, a justice who disagrees may write a dissenting opinion, where they disagree with the majority viewpoint. Finally, a per curiam decision is an opinion issued by the entire court with no author identified. Supreme Court justices and other federal judges are appointed by the United States President with the approval of the United States Senate, and they have lifetime appointments so long as they maintain good behavior, although that's not truly ever been defined. The thinking is that this protects judges from political influence and pressure. There is currently a push to enforce mandatory retirement or limited tenure on Supreme Court justices, as well as the other lower court federal judges. There are a number of reasons for this view, but many agree that a lifetime appointment with no recourse for issues such as dementia or politicized opinions is a cause for concern. There are also a number of specialized courts, which do not fall into the typical rubric we've discussed. The Court of Federal Claims was specifically established for claims against the government. The Court of International Trade was established for international trade disputes and tariff claims. Bankruptcy, tax, and administrative courts are not provided for by Article 3, but were created by Congress due to their niche practice area and specificity. Most state court judicial systems follow some form of hierarchical approach, similar to that of the federal courts. However, some states have their own systems. For example, Louisiana has a Supreme Court and Court of Appeals, but also has Justice of the Peace Courts, Mayor's Courts, and City and Parish Courts. This is because Louisiana follows a French system rather than the English system the remaining United States practice in. New York also varies from the standard system, as their lowest level court is referred to as the Supreme Court, and their highest court is referred to as the Court of Appeals. Indiana follows a similar system to the federal courts, with lower level courts, Superior, Circuit, and Probate, a Court of Appeals, and a Supreme Court. However, Indiana has also established a separate special court known as the Tax Court, with original limited jurisdiction on tax matters. Kentucky also follows a system similar to the federal courts. However, Kentucky has one additional layer to its hierarchy, starting with the district court, rising to the circuit court, maintaining a separate family court, and then the Court of Appeals and Kentucky Supreme Court. It is important to recognize the various forms of judicial philosophy. The first is federalism. Some justices emphasize state autonomy, believing that states should develop their own approaches to criminal procedure. Others argue for national uniformity, believing that consistent standards across all courts ensure fairness and predictability. This tension reflects a broader debate over states' rights versus federal oversight in constitutional interpretation. Precedent. The court values stare decisis, following prior decisions for the purpose of stability. However, justices differ. Some see precedent as nearly binding, while others are more willing to overturn outdated or wrongly decided cases. This shapes whether constitutional protections expand, contract, or shift with time. Bright line rules. Bright line rule advocates favor clear, uniform standards that are easy for police and lower courts to follow. Case-specific justices prefer flexible rulings tailored to the facts, even if it leaves some uncertainty for future cases. The balance affects how predictable or adaptable criminal procedure law becomes. Police power. Some justices express trust in law enforcement and support broader discretion for police. Others worry about potential abuses and favor tighter judicial controls to protect individual rights. Their perspectives often reveal deeper beliefs about security versus liberty interests. State of mind. Debate centers on whether to use objective or subjective standards when evaluating police behavior. An objective standard asks only whether a reasonable basis existed for the action, while subjective standards examine the officer's intent. Was there bias or discrimination involved? The chosen standard deeply impacts rulings on searches, stops, and arrests. Interpretation. Originalists interpret the Constitution based on its original meaning and the framers' intent. Contextualists, or living constitutionalists, see the Constitution as evolving and adapting to modern needs. These interpretive philosophies often explain why justices disagree sharply on issues like privacy, due process, and police powers. Separation of powers. Some justices show judicial restraint, deferring to the elected branches out of respect for democracy. Others adopt a more active role, striking down laws or actions they view as unconstitutional. Their approach shapes the balance of power between courts, Congress, and the executive branch. Consensus. Certain justices work to build unity, seeking clear majority opinions that strengthen the court's authority. Others believe in principled dissent, voicing disagreement to guide future legal change. Consensus, or lack thereof, can influence how stable or contested a ruling becomes over time. Psychology. Justices are human decision makers with unique experiences, values, and biases. Personal background, career path, or even generational perspective can subtly shape how a justice views crime, punishment, and individual rights. Understanding these influences reminds us that the judiciary is both legal and deeply human. Moving forward, we will focus less on the overall structure of the court system and more on the actual procedure that regulates a criminal investigation in trial. I'll see you in Chapter 2.